How can I give myself the best chance in a custody case? Hi, I'm Bill Farias, founder of Farias Family Law, and I met with someone a couple of weeks ago. She's moving toward divorce, and she's afraid that it's going to be a custody battle. She doesn't see eye to eye with her husband on what the parenting time breakdown would be, or even how to raise the kids. And so her question was how she can prepare for a custody dispute. And the easiest way to think about this is DDT. And that stands for do the right thing, document, and take action when necessary. So we'll go one by one. First of all, do the right thing. And what I mean by that is that you have to put the children's interests first. In other words, you do not want to try fitting a square peg into a round hole just because it might get you some extra parenting time if it's not best for the kids. You have to look at it from the perspective of what's best for the kids and work backwards to reverse engineer a parenting plan that makes sense. So don't try to be sneaky, underhanded. Don't inject strain and conflict into the parenting relationship. Sometimes you're going to have to take the high road and just keep quiet or not respond. And these are all examples of doing the right thing. And that doesn't mean that you're not pushing for more parenting time, but it means that you're doing it in the right way. Number 2 is document. And this goes to making sure that you are keeping a log of any significant incident, especially significant incidents involving the other parent and anything relevant to their parenting of the children. And the reason for that is hopefully it works out and you don't have to litigate this or you don't need a contested hearing. But if you do, you're going to have to accurately recount what's happened. And it's not easy to remember all of this stuff, right? Especially if it happened weeks ago, months ago. So it's very helpful to keep a detailed log of significant incidents. So document, err on the side of over documenting, because then your attorney can sift through everything and pick out what he or she needs and discard the rest. But write things down, document them. It might help you later. And finally, take action when necessary. So there's this balance between wanting to avoid whenever possible having to go into court and have a contested hearing. On the other hand, there are some times and some circumstances under which it makes sense for you to take action in court. And sometimes that means immediately. And so whenever you are feeling like an issue needs to be addressed, then you should talk to your attorney about it so that you can decide together when it's the appropriate time to take action. I've seen many people make the mistake of just letting things go for a significant period of time, and they put themselves in a situation where they create bad precedent. In other words, they let things go for too long. It sort of creates a routine or a pattern, and then when they finally get in front of the judge, it's too late because it's been going on for so long, and the judge is going to consider what's happening and what the arrangement has been. And so there are some circumstances under which you need to act quickly. And it's important for you to discuss with your attorney when these issues and situations might be coming up so you can get out ahead of it. So that when you need to take action, you're doing it at the right time and you're not waiting so long that it compromises you on the issue of custody. So how do you give yourself the best chance in a custody case? DDT. Do the right thing, document, and take action when necessary. If you have any other questions about this, you can call us 508-675-0464. You can email us at info@fariasfamilylaw.com. fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel, share it with anyone you think might benefit from it, and you can also find us on social at Farias Family Law. Thank you. Have a good day.